issue over absentee ballots. In 1862, a law was passed to allow soldiers fighting in the Civil War to vote by absentee ballot. Now, there can be no dispute about the validity of the reason offered to vote by absentee ballot. But the Connecticut Supreme Court said, no matter how well-meaning that statute may be, it's unconstitutional. Because the Constitution is what expresses the supreme will of the people. Our government can only act in accordance with the Constitution. And if there's going to be a change, it has to come from the electorate.
Mr. Doss, this is a question from Justice Ecker.
Thank you, Chief. Just to be clear on where we are in your argument, Mr. Doss, I understand you to be arguing essentially the constitutional point, the meaning of unable to appear because of sickness, not your separation of powers argument. Is that where you are?
Yes, Your Honor. We think the most important thing here is the declaration. What's before this court primarily is Judge McCousher's declaration about what the meaning of Article 6, Section 7 means. Does sickness require application to the individual voter, or does it apply to the existence of COVID-19 in general? So
if I may just follow up, just because what I'd like to do is, if I can do it quickly and efficiently, is just clear out the underbrush, if you will. Is it accurate to say that as a practical matter, the separation of powers argument that you made more or less has been put to rest by the ratification by the legislature in 6002, House Bill 602, so that really what we are focused on here at this point is what the words of the Article 6, Section 7 mean?
I agree with that latter portion, that Article 6, Section 7 is really dispositive of this case and the meaning of sickness. But I would say that the new legislation doesn't affect the ability of the court to reach that issue for a number of reasons. The first is that we still have a live controversy. Whether that live controversy is about what Judge McCousher determined about the meaning of the Constitution, that's live. Whether that live controversy is about whether the Secretary's applications when they were issued was constitutional, that's live. And finally, I'd note, and we put it in our briefs, that the ratification itself was not constitutional if you follow the argument that was successfully made by the defendant in the 9-323 action. But Justice Ecker, to your point, really the sum and substance of this appeal, no matter how we slice it, is going to be, can an individual, does sickness in Article 6, Section 7 apply to the individual, or does it apply to the general existence of COVID?
Okay, Mr. Doss, I'm interested in your 923 argument about this court, about my acting as the court and making a ruling concerning primaries versus elections. The court never reached the issue that you are talking about, did I?
The court determined in the published decision that the argument that was raised by the defendant, and we've reproduced on pages 12 and 13 of our reply brief, because there was a choice of candidates as a post for in the primary as opposed to a choice of individuals to serve in the public office, that was the distinction between the primary and the election. And for that reason, they had completely different meaning. Of course, the state constitution uses effectively the same language that the distinction that was argued in 9-323.
But that didn't that didn't touch the statutory scheme that was set up for appeals of primaries and elections, did it?
I believe the court concluded in the decision that it was following the argument that was made by the Secretary of State. That it
was very clear that it was a statutory scheme that was set up for primaries and elections, and that the plaintiff was required to follow a certain statutory scheme. That didn't deal with interpretation of the Constitution at all.
You're exactly right, Your Honor. What we are submitting is that the argument that was presented by the defendant would be no different. We don't even have to change a word of the argument that they presented. But Your Honor is correct. It was there is a distinction between the interpretation of the statute and the interpretation of the statutory scheme. The court did not opine on the constitutional scheme. Our position is that we just can cut and paste the defendant's argument and make the exact same one with respect to the constitutional scheme.
Understood. Thank you very much, sir.
Thank you, Your Honor. And I think, Your Honor, as it comes down to Judge McCousher's decision about Article 6, Section 7 applying to something beyond the tied to the individual voter, I think that's really resolved by the Secretary of State's comments before the legislature in 2012. The Secretary of State conceded to the legislature that the meaning of sickness as it appears in Article 6, Section 7 applies to the individual. And
Did this court ever opine on that issue?
No, Your Honor.
What the Secretary of State said? There are two questions, and I'm sorry, I don't know which order it was, Justice Mullins or Justice Kahn, whichever was.
I'll just jump in. I was curious, Attorney Doss, about those comments and whether you believe we're bound by those comments that the Secretary made, and why, if you think we are.
Yeah, I as far as being a binding authority on this court, no. As far as a tool of construction for how to interpret what the legislature did and the meaning of the constitutional provision, yes. And in Republican Party versus Merrill, this court expressly said we can look particularly at this chief elections officer's explanation for legislation to determine why the legislature did what it did.
But those bills didn't pass, right?
Actually, that's what's unique about this, Justice Mullins. They did, because they were resolutions presented to the legislature, and the legislature approved those resolutions. Now, what didn't pass was when the electorate rejected it. But if you look at what the Secretary of State did, the Secretary of State convinced the legislature to say, you need to amend this Constitution because we need to broaden sickness beyond the individual, tying it to the individual. We want to broaden it, and the language she used, to someone who's providing care for someone who's sick. She used that specific example. And so once the legislature relied on it and approved it by majority vote through 2 legislative sessions, that was the reliance, and Republican Party versus Merrill says that's appropriate to consider.
Does it matter in any way that was several years ago, and maybe time, certainly circumstances have changed, time has passed. Could the Secretary be permitted to take a different view?
And Your Honor, to be very clear, we're not relying just on the Secretary's arguments from an estoppel standpoint. The legislature relied on those representations. And what that does is it tells us that the legislature put to the electorate in 2014 a question, should we amend the Constitution? And they relied on the representations of the chief elections official. They relied on the representations a year later of the League of Women Voters. There was no contrary testimony presented. And so none of that changes what happened with the legislature. They put that question out to the electorate, and the electorate rejected it. So that is evidence when we look at what's the meaning of Article 6, Section 7 that this court is allowed to consider. It's one of the tools of construction. In this particular place, it's a very telling one, because all the branches of government acted in unison on it. And the only thing that happened is the electorate said no. So we know what the original will of the people is. That's what's different. The only thing different about the 1862 case about the Civil War, what the Supreme Court was saying, you need to defer to the electorate, and the electorate gave you this constitutional provision. But if you want them to change it, go ahead and have them changed it. And what happened right after the Supreme Court declared that law to be unconstitutional, the electorate changed the Constitution. Here, you have the Secretary and the League of Women Voters going to the legislature and saying, change the constitutional restriction. It's too restrictive. It only allows individuals who are sick, and that sickness is tied to their individual circumstances. That's the testimony that presented and the reason for the change. The legislature agreed. So they did adopt it, and they passed 2 resolutions. It went to the electorate. The electorate rejected it by 40,000 votes. We can't substitute that.
There's a question from Justice Kahn.
Yes, John.
Attorney Doss, I wanted to give you a chance to answer that, but I think you were going over some of the points you had made earlier. So I want to get back to the word sickness. That word is in the Constitution, correct?
Correct, Your Honor.
All right. So if somebody had COVID, let me give you a hypothetical. If somebody had COVID and wanted an absentee ballot, they would, in your view, qualify as having a sickness, correct?
That's not, I will be very, yes, and I would be very clear, that's only part of the test.
All right. But they would qualify as having a sickness that would warrant an absentee ballot.
That's where I would disagree, Your Honor. And the reason
Why?
I would yes, Your Honor, because the language in the Constitution is unable to appear because of sickness. So if the individual is able to appear, then they would then they wouldn't qualify for an absentee ballot absent a constitutional change.
But
now,
you're tying ability to appear to a physical ability to appear, correct?
That's correct, Your Honor.
What do we do with people that have religious tenets that prevent, they can walk to a polling place, it's just their religious beliefs prevent them. So aren't you reading unable to go to a voting place too broadly?
No.
Or too narrowly, I should say.
Yeah, no, Your Honor.
Physical ability. So how do we, if you're right, that unable to vote in person means they can walk, even sick with COVID, risk infecting everyone, they can walk to a polling place. If that means an ability to walk, even if they may have 105-degree temperature, then what do we do with the part of the words that say inability, unable to vote because of a religious tenet?
Yeah, and I think the answer to that is because the constitutional provision, and keep in mind prior to 1963, the answer is they wouldn't be able to. With the addition of the religious tenets element, the court, the legislature and the electorate, more importantly, has already defined that as an inability to appear. But what we have done, and if you look at our reply brief in particular,
how have they defined that as an inability to appear, unless that's how you interpret the words in that way?
Yes, Your Honor, because there is absolutely no other way to interpret it. That's really the answer. If someone is unable to appear because of their religious tenets, that means their religious tenets are prohibiting them from appearing. But if you have a sickness that makes it unable for you to appear, then you would be unable to appear just under the Constitution. Justice Khan, to put it in the COVID context.
What about somebody with physical disabilities? They're in a wheelchair. They can go, but it's easier for them not to, and to vote via absentee ballot. Is your same, let me finish the question, is your same inability to appear the same? Unable to appear?
Yeah, it is from this standpoint, Your Honor. It is because the question is what the individual voter believes they will be unable to appear based on a sickness, based on a religious tenet, based on a physical disability. That individual assessment has to be made at the voter stage. And so the voter makes that determination. What we have here, and the problem with what we're looking at, and we start with the application, is to say every voter can vote by absentee ballot because of COVID.
But what if, my last question, then I'm an 80-year-old voter, I'm at high risk, and now I've made the decision 2 days before voting day, I'm not, or in this case, whenever the notice came out, that, you know what, it's too risky for me to go to a voting poll. I'm 80 years old. I have a condition. It's in a suppressed immune system that's due to my age. I am unable to go. I can physically walk there, but I'm unable to go because of this. What you're saying is that elderly people who have immune systems that are suppressed are not protected.
Actually, we're saying the opposite, Your Honor. That's that person that you what you just described, that person would be able to appear because it's their sickness, the condition that they have that's making it unable. And that's why I come back to COVID-19 doesn't.
So wait, now you're confusing me. Are you saying that if I'm an 80-year-old voter and I have a suppressed immune system, I'm able to make that decision and say I'm going to stay home because of my risk of COVID?
Yes, Your Honor, and I want to be very clear about this. The rhetoric we hear from the other side is people are being asked to choose between their health and voting, and nothing's further from the truth. If someone genuinely has the inability to appear and vote because of their health conditions and because of COVID, that individual can vote by absentee ballot.
Let me just stop you for a second. I thought you said 5 minutes ago that somebody who had active COVID would still not qualify if they could physically walk to the polling place with 105-degree fever, as long as they could physically get there. So I'm confused. Are you changing your position?
No, Your Honor, I think you summarized our position. We certainly didn't say that. We've constantly, and even in our briefs, used that example that an individual who had health conditions that restricted the ability for them to appear because of COVID would be able to appear by absentee ballot. Maybe the underlying condition didn't allow them to vote last year, but it does this year. And they've been able to do so since 1933. I believe. Yes, Your Honor.
Where would that line be? COVID, this particular disease, if you have certain comorbidities, are all those comorbidities sicknesses?
Your Honor, I think that's for the individual voter to determine.
So hang on. No, I want you to answer the question. Let's say that one of the known comorbidities is a person with blood type A. So would blood type A be a sickness under the Constitution?
If the person, and what I would answer is, our Constitution allows individuals to make a determination if the combination of their health circumstances are going to be affected by COVID.
The Constitution says sickness, and I want to know how you are defining sickness. It's a yes or no question, I think. And if you have blood type A, would that be a sickness where a person can say that I have a sickness and therefore I want an absentee ballot?
I think, again, it would be the combination of the personal health conditions and COVID-19. That's why I come back to
the personal health condition that I'm asking about is blood type A and nothing else. You have blood type A and that's it.
And Your Honor, again, without being able to set, I don't think we have blanket rules on this. It's an individual determination that has to be made. And that's what the Texas Supreme Court said. Everyone needs to evaluate their individual health.
Texas has a different constitution and statutory construction and circumstance that we have. I understand the Texas case, but that's a different situation. What I'm trying to drill down on here is what is the definition of sickness? Because I think that is the crux of what's going on here. Whether a person can say, because I fear COVID, they can check the box and not commit a fraud.
Yeah, Your Honor, I guess that's the point. If it's just I fear COVID for the sake of fearing COVID, then I don't think that person would qualify. But if they fear it because of their personal health, that person would be able to check it off.
But personal health is not a substitute for sickness, and that's what I'm trying to understand. And I'm really trying to just understand that because I think there are two slightly different issues here. One is what is sickness, and one is if a person, sort of this general thing that if you fear sickness, then you can't check this box, or the box can't be there actually.
Yeah, and let's be very clear, Chief Justice Robinson. The rule that the Secretary has issued wasn't you fear COVID. It's COVID allows me to check everybody off. So even if they could appear and it's just inconvenient, they get to vote by absentee ballot, and that's really the main substance of why.
If I had the sniffles and I really felt that I wasn't able to go because of the illness of sniffles, or I have sniffles, I might have COVID. You're supposed to quarantine yourself, right? And so you may be sick, you don't know, you want to check the box. What about that circumstance?
And the answer is
that person sick?
I would say that they would have, if they believed in good faith, they could check off illness, then they would be able to get an absentee ballot. And that's been the rule since 1933. And I don't see that as
so almost anything would fall under sickness that an individual said, hey, because I'm trying to figure out how you'd even be able to challenge it anyway. But if a person said, there's no box, COVID box, the person checks sickness because, well, quite frankly, they're afraid of COVID. You can't really challenge that, can you?
No, Your Honor, and that's kind of one of the issues we have with the Secretary using these circumstances to broaden the expansion of who can vote by absentee ballot by just saying everyone can, because it sounds rather
mechanical, and I know this isn't one of those situations, but it's almost like exalting form over substance.
Yeah, it's not extorting form of substance because it's complying with the Constitution. The Constitution
I get it.
provides
I understand that.
And that's a significant distinction, because what we can't do is use absentee voting to expand it to everybody, because the Constitution puts that restriction in place. The electorate has already done so. I realize I'm running a little bit out of time, and I know Justice Ecker has a question.
One more question. Justice Ecker, actually, you can go first, and then I have one more question for Mr. Doss. And then Justice Mullins.
I was just wondering, in terms of constitutional interpretation, Mr. Doss, do you have any contemporaneous or other evidence about what sickness means? You know, the trial court makes a nice point that it doesn't say his or her, it doesn't say their sickness. It says sickness, and sickness can mean pandemic or plague or polio or Spanish flu or all these. We don't know what the legislature had in mind, at least I don't. And I'm wondering if you have any way to help us through the usual rules of constitutional interpretation to know whether you're right or whether the trial court was right.
Yes, Your Honor, and the answer is the entire statutory scheme going from 1933 to 2012. When one of the rules, and you used it in Republican Party versus Merrill, is to look at how the legislature used the same words. So if you look at the language from 1933, it says because of sickness or physical disability. That in 2012 changes to his or her illness. But every single change where we added the modifier in 1986, his, and we added the modifier his or her in 2012 were technical revisions, which meant the meaning of the language going back to 1933, when this contemporaneously was added in response to the Constitution, has the exact same meaning it has today. And
well, I mean, it may tell us something about what the legislature believed the language meant at some point, or what the legislature believed was a narrower construction because it didn't want to go to the constitutional limits. But I'm wondering just about, for example, in the in any of the legislative history relating to the passage of the resolution itself, or any other kind of historical basis that you can help us with. That's used in other cases, when you're interpreting the Second Amendment, for example. Do you have anything that can help us other than what you just named?
Yes, Your Honor. Mr. Chief Justice, I see my time's expired. May I have a moment to answer the question? Thank you, Your Honor. I give you two sources, Your Honor. First, I'd start off with the very first hearing that was held on this in 1929 to determine why we added sickness into the Constitution. And the examples that were given, because three things were added in 1932 based on the 1929 hearing: out of state, sickness, physical disability. And two of those examples that were given, that were testified to, were individuals who were sick or physically disabled. Flash forward 2012. The next time the court had an attempt to amend this Constitution, well,
let me interrupt you there, though, Mr. Doss. What about just being out of the jurisdiction because I have to be in East Haven all day because my friend is having a pool party on in November, which is unusual, and I want to make the most out of it. So I'm going to get there before the polls open, and I'm going to stay there until after they close because I love to swim in November. That's a perfectly legitimate constitutional reason to vote by absentee ballot, right?
That's correct, Your Honor.
Yeah. So it's not really, doesn't that suggest that it's not really such a restrictive and extreme requirement as you're suggesting? I mean, if it's that liberal in that context, then how can it be so strict in a context right next door?
And Your Honor, I think the answer is that the electorate has chosen which categories individuals will be able to vote on, and they're not looking at the reason when you're out of the jurisdiction. But let me respond to that very quickly by noting.
But I mean, that's the question, Mr. Doss, right? Is what did the electorate mean? So it doesn't help us to say, well, it's because of what the electorate meant.
Well, here's a quick answer to that, Your Honor. The U.S. Supreme Court addressed in McDonald versus Federal Elections of Chicago, 1969, footnote 8, a number of very valid reasons that people should be able to vote by absentee ballot, but under Illinois law, they weren't allowed to. One of the best examples was a medical doctor who had to perform medical services outside his, but was going to be in town for a portion of it. So he wasn't going to be entitled to vote by absentee ballot. There are a number of very good reasons why people should be able to vote by absentee ballot, but the electorate has defined that. And Justice Ecker, they did answer that question in 2014, not just because they said that we're not going to expand absentee ballot voting, but both legislatures that passed it, 2012, 2013, did it in response to this very question. And so if the electorate was going to agree with the legislature, they would have adopted those amendments. And I realize my time is up, Mr. Chief Justice.
Thank you, Mr. Doss. I believe there are two justices and myself who still have some questions, though. Justice Mullins?
I'll ask it. Why not? I just was listening to the earlier conversation and was curious about your take on, I guess, two things. Why our view of sickness in the Constitution, our interpretation of it, shouldn't include sort of like a public health kind of concern and a kind of holistic view of what sickness should mean. And tied to that, I was thinking about listening to the conversation with the Chief Justice, anxiety. Anxiety itself, I think, can be a sickness, right? And anxiety can prevent you from going to the polls. So you could be a person in today's society with COVID and its effects and have real anxiety about going to a polling place where there are going to be a number of other people. We have the governor, we have all of our health professionals telling us to, social distance and stay home and do our part to do that in this age. Can't that create anxiety? And why wouldn't that be a sickness that could fit in? Maybe you could check the regular box of sickness, but why couldn't you check the COVID box? Why wouldn't this fit?
Sure. I'll address all three questions in order, if I may. Let me start with the first question, which is why you shouldn't give it a broad rating. And the answer is because it's an exception to the rule. Default rule is you're not able to vote by absentee voting. That's been the jurisprudence recognized by this court in cases as recently as Keeley. That's been the application by the State Elections Enforcement Commission, which is in charge with adjudicating this principle. So that's the default rules. You can't vote by absentee ballot unless you fit one of the exceptions. With respect to your anxiety example, Justice Mullins, again, we're coming back to individual decisions about whether someone fits within the illness box. And what we have here, and that's what's different than what we have that's been presented by the secretary here, is an expansion to say everyone can vote by absentee ballot. That's the problem. It has to be narrowly tailored to each individual to make that decision. And that's what Texas said, and that's why we're asking for that principle to be followed. The hardest thing that the state has in defending their position is they have to argue the extreme. They have to argue that every single voter in Connecticut can vote by absentee ballot. The questions you're presenting us with are the exceptions. And the exceptions are taken on a case-by-case basis. And I think through the court's questions about how does that get enforced, the answer is our own moral convictions. We trust the voters to make a determination of whether they fit one of those boxes or not. The problem we have here is the secretary informed every single voter in Connecticut, hey, don't worry about your individualized ability to appear at the poll. Every single voter can vote by absentee ballot now that we have COVID-19. And that's unconstitutional because it goes well beyond what the Constitution provided in 1932 when the provision was enacted, and it goes well beyond what was provided in 2012, which is exactly why this question was sent to the electorate and it was rejected in 2014.
Can I just try to just a little bit differently? Maybe I'm understanding it wrong, but I don't know that it necessarily includes every person. I mean, the language does, but the reason I asked about anxiety is because, to some extent, maybe all of us are experiencing some anxiety, but some of us will check the box and some of us won't. Just like those who have a sickness that we could agree qualifies as a sickness, maybe no two people will treat that the same way. Some people will say, I want to get up and go, and others will say, I won't. So that's why I was curious about anxiety, because it's something, this pandemic kind of affects us all in one way or another. And this category seems to be a way to allow people who feel anxiety, or if you'll indulge me, call that a sickness, to be able to check that box without committing fraud. But you could experience the same thing and have the same feelings and have the personal decision that you can go to the poll you want to go. I'm not sure why that shouldn't be our interpretation of this constitutional provision.
And Your Honor, what I come back to that is say exactly what the issue Judge McAllister teed up is. Does sickness tie to the individual, or is it just the mere existence of a particular issue, a pandemic, a sickness? So the existence of anxiety, for example, Justice Mullins, wouldn't mean that every single person gets to go out and vote by absentee ballot. Maybe the fact that you're conscious about the fact that other people are going to be uncomfortable with people being out there because of anxiety. Maybe but an individual who's really uncomfortable with going because they have anxiety would be able to vote by illness. We don't require doctor's notes. They make that individual assessment. The problem here is to say that everyone can vote because of COVID, even though you can, participate in a rally, you can go to Home Depot, you can go to the Walmart, and yet you still get to vote.
Justice Mullins, may I?
Yeah, absolutely.
The problem that I'm having with that argument is you're saying your argument is that this allows everyone to file absentee ballots. Isn't it really limited to those who want to check that COVID box? It says if you check this box, the Secretary's order, if you check this box, you cannot be prosecuted for committing a fraud. You can choose not to check the box, but how would a person who is suffering from this, to use Justice Mullins' terms, anxiety, know that they could check, they don't have to check the sickness box, that anxiety is actually covered by this provision? How would they know that?
So in the explanatory text in the application, it was advised that if the illness, your inability to appear was because of an underlying condition, to touch on Justice Kahn's example, or something that your personal conditions with respect to anxiety are going to touch are related to COVID, you would check the illness box. The COVID box was created as a broader blanket rule, and that's the problem. Since 1933, you could
has the Secretary, is there an agreement that that's what the Secretary was saying?
It's cited in the application, Your Honor. It's quoted in the application. The distinction between checking illness and checking COVID-19 was just the distinction that you just mentioned. If your personal health circumstances mean that you can't go to the polls, you check illness, even if it's COVID related.
Right.
But if it's anything else, you check COVID. It was a creation of a brand new area. That is what the problem is.
No, I think you're conflating some things that at least maybe I'm conflating some things. If you feel that you don't want to go out to the polls, you have this anxiety. I guess your argument really is that anxiety would have to rise to the level of a sickness. And the problem that I'm having with that is now we're telling people what sicknesses are included, what sicknesses aren't. And the Constitution doesn't do that.
Yeah, Your Honor, I don't think we're telling people that. I think what we're telling people, if you are unable to appear at the polls because of sickness, as you interpret that phrase, you would be
I'm not interpreting the phrase. I'm saying that's what I'm trying to figure out, how to interpret the phrase.
No, the individual would. I mean, and that's what Texas says. Let the individual make that determination. Don't give a broad, bland statement, which is what the Secretary did here, saying everyone gets to vote by COVID, because that's not accurate. The Constitution allows it to be individualized.
Okay, I'm not trying to cut you off. I'm just trying to get through a lot, and we're already over time. Can reasonable jurists disagree with what you're saying?
I don't think on the basic constitutional provision about whether everyone can vote by absentee ballot.
No. Whether this whole we're sort of going around in circles on anxiety and illness and all these other things, and I'm getting twisted in knots, and I'm trying to figure out if we're getting this twisted around, can reasonable jurists disagree on this issue?
I'd even go further and say reasonable people could disagree on their individual circumstances, which is why we entrust the voters to make that individual determination. And we have since 1930.
But that's not answering my question. My question is, can reasonable people disagree about the interpretation of sickness? Reasonable jurists.
Yes, I think as far as
reasonable jurists disagree on how this issue presents itself in this case?
Yes, and I will say no, because if I could answer that two-prong, Your Honor. No, because I think under the plain meaning and the dictionary definitions we provided of unable to appear because of sickness. I think individuals can disagree about their personal circumstances, and that's why we don't second guess that. But most importantly, I think if you do disagree, if reasonable jurists can disagree, then you have to look at the other tools of construction, and every one of them falls in our favor.
Well, I think you see which direction I'm going in, which is what standard do we review the governor's order by, as well as the secretary's order, as far as the constitutionality of those orders are concerned? Not the secretary's order, the secretary's interpretation.
And the answer is because it's a constitutional provision. The most authoritative source is the Connecticut Supreme Court, Marbury versus Madison. You don't have any deference to the other branches of government when it comes to interpreting the meaning of our Connecticut Constitution.
And but the act itself of the secretary and of the governor, are those by reasonable, beyond a reasonable doubt? How do we look at those? How do we review those? So
I guess let me square up to come back to what Justice Ecker asked from the very beginning. Mm-hmm. The issue before this court, because of the way this has been procedurally set up, is the declaration that Judge McCousher issued. The only legal question before this court is, does sickness under the Constitution apply to the individual or the existence of COVID? Everything else, Your Honor, that comes from that, whether it's injunctive relief, the remedy, everything else, the review of actions of the secretary and the governor, they all come secondary to that declaration. But because we're here on a 5229 and not some other proceeding, all those would be remanded back and we'd have consideration on what that remedy might be.
All right, I have two more quick questions for you. The Purcell Doctrine, I haven't heard you mention that yet. The primary is August 11th, which is Tuesday. Why should we or should we not invoke the Purcell Doctrine?
Yeah, two reasons. Obviously, I'll start with the most basic is Purcell Doctrine is a federal rule and not one binding on state courts. But let me jump to the more significant issue, which is that, again, the only thing before this court is the declaration. What does Article 6, Section 7 apply? The application of that to the primary or to the general election is something that the trial court may address on remand or in a subsequent proceeding. That declaration.
But how do you do that without interfering in the election itself, which occurs Tuesday?
Well, I think the court would, when this gets remanded, the court would then have to evaluate the factors, and that comes into the balancing of equities. Is this something that would be reasonable for the court to intervene in with the benefit of the declaration? It may come up in a post-election challenge. It may come up in a post-primary challenge. It may come up in a pre-election challenge. The declaration is the important thing because that's what already was issued. That's the only thing you're reviewing.
But still, you were saying that wouldn't have any, wouldn't affect the primary in any way?
Possibly. At this point, it would depend on the judge, trial judge, to make a determination of whether injunctive relief would be available. Purcell may be considered before Tuesday, and the court may say.
So this court would have to make its decision. It would have to get down there, and then have to do all this before Tuesday, preferably early Monday or Friday. It's only 2 business days left.
And Mr. Chief Justice, even if that were not the case and we didn't have that declaration, when we have the benefit of that declaration, because keep in mind, there's no injunctive relief before this court, the court could allow it to go forward and get that declaration. Perhaps a primary challenge is available. Perhaps we have guidance.
You mentioned that. What would happen? We didn't deal with the agreement issue yet, and I don't think we're going to have time to. We have it in your briefs, but nobody from the Democratic primary are members of our parties in this case, right?
Well, they filed an amicus brief, so they are
filed an amicus, but that's it. They don't have a representative to argue at this court or at the trial court. right?
And the answer is
you could actually end up with this sort of bizarre situation where you can get injunctive relief in the Republican primary, but maybe not the Democratic primary.
well, so Your Honor, we don't know what we could get for terms of
No,
injunction.
I don't know. I'm just saying that could
Right.
be one of the things could happen.
And that would be something for the trial court to determine. What I will say about the declaratory relief, and this is significant, because once this court declares, in our hope that Article 6, Section 7 applies to the individual, then the value of that declaration is that it could be applied by the Republicans or the Democrats in a post-primary challenge or in an action related to what might happen with the general election. But that declaration is what's guiding it. And keep in mind, Chief Justice Robinson, this is the only way to address that, because as Your Honor made clear in the 9-323 action, this issue couldn't be raised in that action. So we'd all have the benefit of this legal determination that Judge McAllister's already ruled on.
But you could have filed the proper action timely. That's the laches argument that we don't have time to get into right now.
But which
the last one I want to ask you is about the Geisler factors. Is the decision of the legislature to pass the bill that they passed, can that be used as one of the Geisler factors?
I guess which factor would Your Honor think it would come under?
Social policy.
I from a constitutional standpoint, I don't think so, because we're only dealing again with the declaration and they weren't opining on the constitutionality. I think the Geisler's factor's most contemporary recent issue with respect to interpreting the constitutional provision has to be the 2012 amendment, because that was what was directed at the Constitution. If there had been a constitutional amendment proposed this time around in the most recent legislation, then perhaps.
Have we ever cabined the social policy factor to be like you're stating now? That seems rather bizarre. That it would have to be that the legislature would explicitly say we're dealing with the constitutionality of this issue, and therefore the social policy is this because of the constitutionality of this issue. Unusual.
Well, it is, but we have an unusual set of circumstances where, this case was briefed last week, and the new legislation we're dealing with on July 31st without any hearings and without any public testimony, without all of the reliable factors we had when we were dealing with a change in the Constitution, which, to be very clear, was not the issue or even considered in the most recent legislation.
Thank you. Thank you, Mr. Das. I'm sorry for asking so many questions. And
no, thank you. I appreciate it.
So long, but I appreciate your answers. For the appellee, I'll give you additional time to work with this. Right now, we'll stick with the 30 and then see how that works out. Okay?
Thank you, Your Honor. May it please the court, I'm Assistant Attorney General Michael Skolden, and I represent the Secretary of the State in this appeal. Your Honors, the executive order that plaintiffs seek to challenge in this case is a common sense and necessary health and safety measure that is designed to save lives and ensure that every Connecticut voter can safely exercise their fundamental right to vote.
Yes, hold on 1 second. Did we completely lose Mr. Das, or did he just turn his video off? Mr. Das, are you there? I just want to make sure we didn't lose you. Sorry, counsel. Please continue.
It is a necessary health and safety measure designed to save lives and ensure that every Connecticut voter can safely and effectively exercise their fundamental right to vote during the August primaries without the risk of spreading or contracting the disease of COVID-19. And although initially issued by the governor, the executive order has since received the near unanimous support of the entire General Assembly, which voted overwhelmingly and on a bipartisan basis to not only ratify the executive order for the primaries in August, but yes, Your Honor.
I want to try to get in here before I don't have a chance. I understand that part of your argument. I'm curious if you could connect that to how we should interpret the term sickness, because whatever the merit of the reasonableness of the governor's executive order to protect public safety, whatever the merit of that, how does that relate to an interpretation of what those words mean in the statute? If you could connect that, because I could see maybe they do, but there's at least a plausible argument that the words mean what they mean, and however that shakes out is how it shakes out.
Absolutely, Your Honor. And to do that, Your Honor would have to go to the Geisler factors, the first one of which is the text, which the trial court determined was clear and dispositive, and the Secretary agrees with that. The Constitution provides that individuals can vote by absentee ballot if they're unable to appear because of sickness. And those are the only three words that the Constitution uses. And that's a broad authorization for absentee voting. And if you just look at the text,
but
there's only
it's not clear. The text, would you say the text is clear and unambiguous, or is it ambiguous?
Well, I think certainly the trial court found it to be clear and unambiguous, and I do think it's unambiguous when you look at the text, especially in relation to the other language for other reasons in the constitutional provision. For sickness and for physical disability, the framers said because of sickness, so there's two requirements. One is there must be a sickness, and then there's the unable to appear because of it. With regard to the sickness, the framers did not identify who has to have that sickness. They did not identify an object to whom that sickness must apply. They just said sickness. And contrary to the sickness and physical disability examples in the Constitution, for other reasons for voting absentee in that same provision, the framers did tie it specifically to the individual voter. And the most glaring example of that is the religion example. For that, the framers said that individuals can vote absentee if they're unable to appear because of their religion. It used the word "their." It didn't do that for sickness or physical disability. And when they used the word "their" in connection right next to the word religion, they were clearly intending to express their intent that it has to be that individual's own religion that prohibits them from going to the polls. And if you apply basic principles of construction that this court applies on a regular basis, when the legislature, or in this case the framers, use one word for one example in the provision, but deliberately omit that word from another related example. Yes, Your Honor, just a second.
You can finish if you're not done with your answer. Go ahead and finish. I don't want to interrupt. I was just raising my hand to indicate that I had a question when you were done.
Okay. So when they used the word "there" specifically with regard to religion, but did not use it with regard to sickness and physical disability, that is intended to signify a different meaning, and this court has to construe the language differently when that word is missing.
Could I just have one follow-up before you go, Justice Ecker? I'm just so it seems though that sickness. I'm curious about your response to the plaintiff's point that the only way to interpret the religious exemption is it has to be related to your particular religion and your particular religious belief that would sort of make you unable to appear. Sickness, there's at least, I mean, I think you said it was unambiguous, but you wouldn't say there's at least a reasonable view that the way sickness has been interpreted throughout the years, dating back to the 1800s or whenever this provision came to be, the sickness provision, that it was believed to be your sickness, not a general sickness?
I just would take issue with the statement that that's how it's been interpreted. Nobody in Connecticut has interpreted it that way, Your Honor. And in fact, in other states, the Arkansas Supreme Court, the Forrest versus Baker case that we've cited in our brief that plaintiffs totally ignore, in that case, they interpreted identical language because of illness, consistent with the Secretary's position to mean that it could mean somebody else's illness in the family, for example, that you're caring for. So I don't think it's true that it's been interpreted to be the individual's sickness. And with regard to the
court, maybe not a court, but the Secretary herself viewed this more narrowly than I guess she does now. And, we may not be bound by that, but isn't that a tool of construction we can use in interpreting this provision?
Well, I think the first point I'd make with regard to the Secretary's 2012 testimony is that the plaintiffs are mischaracterizing it. So that her testimony was in relation to a constitutional amendment to make no excuse absentee balloting, and she had a large amount of testimony on that. And at the end, she did reference, among many other examples, things that people are not able to vote absentee ballot for, one of which was caregivers. But when she made that statement, she prefaced it with the Constitution and the laws of this state. That was the statement that she made in her testimony. And the laws of this state, which was General Statute Section 9-135, that statute did say his or her illness. So under the statute, there's no dispute that a healthy caregiver could not vote absentee under the pre-EO version of Section 9-135. But I don't think the secretary was in any way opining on the meaning of because of sickness. She was advocating for a legislative amendment to no excuse absentee balloting, and she just gave one example. So I don't think her testimony informs the analysis at all.
Thank you.
Yes.
I'll ask my question to Justice Ecker.
Go ahead, Chief. I can wait. I want to. No, okay. Thank you. We're all too polite here, aren't we? So I guess your position then, Mr. Skold, is that the Constitution itself, apart from the statutory regime, the Constitution would have allowed caregiving as a justification for absentee voting, even before the executive order. If you were taking care of an ill or elderly parent who was sick or something, then under the Constitution, that would be encompassed within sickness.
That's correct, Your Honor. I think the Constitution would permit that, and whether the General Assembly chooses to implement that is the General Assembly's choice. And the General Assembly through 9-135 chose not to implement it as broadly as that. That was a legislative choice, but it was not a constitutional requirement.
So I want to the only other question I have for you at the moment is the same one I asked of Attorney Das. I mean, I understand the Geisler factors have been used in other cases, even with the sort of unusual or sui generis constitutional provision. I'm not sure the Geisler factors are terribly helpful, in a constitutional analysis when we're dealing with our own provision that's unlike that anywhere else. Pretty unusual. So let's just get right at the constitutional interpretation question. I mean, normally we would be pretty interested, whether you're an originalist or not, you'd be pretty interested in what was meant at the time based on historical evidence. Do you have any information that would illuminate that for us?
We have looked at the history of the constitutional amendment from 1932, Your Honor, and there's nothing in it that would shed light on this. I mean, I think the provision at issue was largely didn't generate much interest at all in the populace at the time. It was just kind of taken as an assumption. And as far as the debates go, I know that the plaintiffs have referenced some language from one of the hearings in 1929, which we've included in our appendix, Your Honor. That does not shed any light at all. There's two comments in there from two individual legislators who were speaking. They were just giving anecdotal examples of experiences in their own life that have caused them to want to support absentee balloting. It did not in any way suggest what the meaning of the full scope of this provision is. So the short answer is there's nothing in the history that
there's nothing helpful. I'm just looking for other ways to do the constitutional interpretation. Putting aside the Geisler factors, the typical constitutional interpretation that we conduct, I guess textualism is what the trial court used. Do we know anything about whether the word contagion was popular or used at that point? I mean, I suppose I could say, well, they didn't say their sickness, but they also didn't say sickness or contagion. Is there anything else that you can give us other than sort of relying back on what's reasonable for a executive to do under conditions of a pandemic?
Well, that's certainly not the only thing we're relying on, Your Honor. We're relying on the text and how it's been interpreted. Similar text has been interpreted by our courts and other states. But with regard to the history, no, I wish I had more for Your Honor, but there just isn't anything in there that I'm aware of that would speak to that particular issue from the historical perspective, at least that we're aware of. But so I think the text.
Mr. Skoll?
Oh, yes.
Just to sort of pull this thread that Justice Ecker was pulling. We had the 1918 pandemic, which reemerged in the 1930s as the 1930 pandemic because the virus had mutated. The fact that we had this constitutional change after both those events, yet the language is the Constitution didn't change, does that mean anything to you?
To me, it would suggest that those things would be included within the language, Your Honor. If that's the type of the history of what was going on at the time, that the framers would have been well aware of those diseases being prevalent, and their choice not to use the word there or tie it to the individual, to me, again, going back to the text, not including the word there or his or her, would suggest to me that they were intending a broader meaning, especially when then they. Sorry.
And not speaking for Mr. Das, but I suppose his argument would be, or they could have been aware of the circumstances, aware of the Constitution, which is what the legal presumption we use, and they didn't change it. They intentionally didn't change it because they didn't think that there should be this change to allow more people to use absentee balloting.
But that just begs the question, Your Honor, of what the original language meant. And if there was no need to change it, then they wouldn't have changed it because it already was included within the constitutional language. And I'm not aware of anything from a court or a legislator or any other state actor around that time who would have suggested that the words "because of sickness" was limited in the manner that the plaintiffs are suggesting. There's no authority for that anywhere, and the plaintiffs haven't cited any. And the case law is to the contrary from other states. The Arkansas case that we cite, Forrest versus Baker, and the Parker versus Brooks case from our Superior Court, which I understand is obviously not binding, but it's still persuasive authority from within this jurisdiction.
I hope I'm not going too far afield with this question, but suppose that the trial court said that the text was clear and unambiguous, and so the tools that we use of statutory interpretation is basically that's what you're stuck with, that's what you have. What would happen if, despite the fact that the text was clear and unambiguous, the behavior of the legislature and the executive branch was such that it created an ambiguity? What would we do then?
Well, I think that would be going beyond the text. I mean, if the text is unambiguous, then it's unambiguous. But
I guess what I'm asking is, can it subsequently be made ambiguous? And I don't think we've ever dealt with that situation.
Well, I'm not sure that subsequent actions by other state actors would be enough to render the plain language of the statute ambiguous. So I would say no, Your Honor. But there is nothing that has happened since the initial language was passed into the Constitution to suggest that there was a different meaning. Now, I know the plaintiffs have relied on the genealogy of Section 9-135, but all that tells us is that for the 50 years after the constitutional provision went in, the legislature used the same language as the Constitution. And there was nothing interpreting that or anything until 1986, when an entirely different General Assembly made up of different legislators made amendments that they considered to be technical. I think the fact that a different General Assembly 50 years later makes technical amendments doesn't speak anything to what the framers meant when they applied it. And it certainly doesn't mean more than what this General Assembly meant about its understanding now. Yes, Your Honor.
Mr. Skoll, Judge Mall has a question.
Mr. Skoll, I wanted to ask you a few questions about your latches argument. My understanding is that the defendant didn't file an answer below, and I assume that there was some kind of agreement that the typical pleading requirements would be suspended. How did it come to pass? I mean, I know you argued, orally a latches defense before Judge Mukausher, but how did it come to be that there was no answer filed by the defendant? There was no agreement on any of that, Your Honor. The complaint was filed, and then the next day the trial court set a hearing. And at that hearing, the defendant raised an oral motion to dismiss, which the trial court denied, and then the trial court proceeded to hear the merits and decided them. So there was no opportunity to file an answer. So do you agree that Judge Mukausher did no fact finding with regard to your laches defense?
He did not do any fact finding, Your Honor. We did raise the laches argument in the hearing and asked for an opportunity to present evidence on that. We did submit 2 affidavits from the Ted Bromley, who's the director of elections from SOTS, but the trial court found it unnecessary to address that because he dismissed it on the merits.
So you've now raised laches as an alternative ground for affirmance of the judgment. So my question then is, are you aware of any appellate authority where either the Supreme Court or the appellate court affirmed a judgment based on a defense where the trial court had done no fact-finding?
Where they affirmed the judgment on the basis of that defense?
Correct, which is essentially what you're doing here.
I'm not aware of that, Your Honor. This is an extraordinary case where the matter was decided one day after the complaint was filed. But I would say that if the court is inclined to agree with us on the laches defense, or at least think there's an issue there, then the court should not grant any relief on the merits of this case. So no, the short answer to your question is I'm not aware of appellate authority that would permit that.
Okay. All right. Thank you.
Justice Kahn.
Can you hear me now? Can you hear me now?
I can hear you, Your Honor.
Okay. We had to have one of those moments. Sorry.
Justice Kahn, I think you
Yes.
may have hit the share screen button.
Oh.
There
How
we
is
go.
that? Is that better? Sorry about that. It's right next to the mute button that was on. Counsel, this question may be better for Attorney Doss, but as I listened to his argument, he basically, with a series of hypotheticals, indicated that his client would have no problem with someone checking off sickness if they had anxiety and were nervous to go to the polls because of COVID risk, or if somebody's 80 years old, to my particular hypothetical, and has an immune suppressed system because of age, not any particular illness, just age, and is uncomfortable, doesn't want to not go to the polls because of their age, that would fall under sickness. So I wonder is what we're fighting about here the form itself? Because when I listen to Attorney Proloy Doss, it would suggest that if the secretary had just amended the form to say sickness includes COVID next to the word sickness, then would we be here? That's how I'm reading his argument, because what he's saying is it's that there's a section added for COVID, and he reads that to mean everyone can check off COVID, as opposed to people making an individualized decision. But it sounds like any person who has concerns about catching COVID could opt for an absentee ballot. I didn't hear him to say that he would have a problem with that, but maybe that's, in fairness, a better question for him. But it seems to me he's trying to put COVID and its risks under the term sickness, yet objects to a form that seems to sort of spell it out. Or would it be just that the secretary could give guidance, could send a memo with an absent, I just don't, I wonder is what we're fighting over forms then, given his explanation. Sorry.
I think I agree with Your Honor that the plaintiff's argument really is just putting form over substance, because the reality is that every individual voter is eligible to state on the application that they are unable to appear because of the sickness of COVID-19. That doesn't mean that they have to. That's a choice that they are making because of their own circumstances. And I think that's exactly what you heard plaintiffs say repeatedly, is that it's down to every voter. And we agree with that. Not every voter has to vote absentee ballot. If they want to go to the polls, they still can. But the reality is that this particular sickness and the nature of the disease and the ease with which it spreads, the fact that there's no vaccine or treatment, and the deadliness of the disease is such that that excuse, that reason for voting absentee, applies to every voter who feels that they are unable to appear. And to your point on what it means to be unable to appear, Your Honor, the other examples given in the Constitution, religion, and absence from the town of voting, make very clear that unable to appear doesn't mean you have to be physically incapable of going. Somebody could be out of town in Rhode Island, 45 minutes from their home on vacation. That person is eligible to vote absentee, not because they can't go to the polls, but because they're making a choice to be in another place. And that's what our Constitution and our statutes permit the voters to make that choice. We're just extending that, the executive order has extended that same choice to individuals who feel that they are unable to appear because of COVID-19, Your Honor. And I think that this is confirmed by a point that the trial court made in its decision that I found very persuasive, was that the amount of people that have been killed in Connecticut during COVID-19 is 4,300. That's about the same as the total number of Connecticut residents that died during World War II, Korea, and the Vietnam War combined over 10 years. And that just goes to show the lethality of what we're dealing with here, and how it is entirely appropriate and lawful and constitutional for an individual to say that I am unable to appear. I don't feel that I can go to the polls in this context. Yes, Justice Robinson.
Just kind of you through with your question. Mr. Skoll, I noted during the last hearing that I heard as a justice of the court, which was Fay 1, the language is unusual in both the executive order and in the secretary's interpretation. The Constitution says sickness, and the executive order and the secretary's interpretation adds the article the sickness of COVID, or the sickness of COVID. What does that word mean? The THE, the article that appears there, because and I'm not trying to put words in Mr. Doss's mind. I'm trying to think of what he would say. He would say that adding that article and extending sickness to everyone is unconstitutional, because the Constitution doesn't say that, and that sickness means the individual.
I think that they used the word because saying sick, had they written it to say an individual can vote absentee because of sickness of COVID-19, that just doesn't make grammatical sense. I think they were putting in to describe the sickness of COVID-19. But I think the real point is that neither the Constitution does not have any other language in it that would tie it to the individual voter the way the General Statute Section 9-135 does. That's really the answer to that, Your Honor. And it just says sickness, and the governor in the executive order is describing a particular sickness that is the basis for the order in this case.
Justice Ecker?
I think Justice Mullins had a question. I
My
don't know.
apologies. My apologies to Justice Mullins. Justice Mullins?
Very quickly. Thank you, Justice Eckert. I am just curious about why. Did I misunderstand you that if someone felt like they were fearful, is the word I used earlier was anxiety about COVID-19, that they could check the My Illness box?
No, they would check the COVID-19 box.
Suppose there was no COVID-19 box.
Well, I think that gets into the questions that Your Honors were asking earlier about what rises to the level of a sickness, and the Constitution doesn't specify that, and which is why the governor's executive order is appropriate. It makes it clear that this sickness is a sickness. It's a very lethal one, and it's the excuse for voting absentee in this context. And I don't think that we have to.
Well, can I just ask you for clarification, because I'm not sure. Without the COVID-19 box, it is at least not confusing to me that COVID-19 is a sickness. I mean, that part is true. The issue might be whether that fits into, unless you have it, not having it and being afraid to contract it, maybe that is the question of whether it fits into my illness. But if there is a sickness, I'm still not quite clear on exactly what a sickness is. But if there is one, it seems like COVID-19 or the coronavirus would be a sickness. It's just you get to access that if you don't actually have it, if it's not your sickness, I guess.
Well, so that's the reason for the executive order is to address that issue of whether or not you have to have it. The Secretary of the State issued an opinion interpreting Section 9-135 before the executive order was passed, and that's, I don't believe that's in the appendix in this case, but it is in the appendix in Phase 1. And in that opinion, the secretary opined about what my illness means, and it does include pre-existing conditions like anxiety or whatever they might be that would cause someone to consider themselves unable to go to the polls. So if an individual has a pre-existing illness that coupled with COVID-19 would make them unable to go to the polls, even if ordinarily they wouldn't be able to, they could check the my illness box. But really what the executive order is addressing is somebody who doesn't have an illness, but is, because of the nature of this particular disease, which is a sickness, feels that they're unable to go to the polls.
Okay, so that's the distinction between the my illness box and the COVID-19 boxes. Is for the COVID-19 box, you don't even, the view is you don't have to have it at all. Just the fact that it exists allows you to check that box.
Right, and the reason is that because, first of all, it is a sickness, and it's entirely appropriate for somebody to feel that they are unable to go to the polls because of that, given that it's a highly infectious disease. It kills a lot of people. There's no treatment. There's no all of that. Okay,
in terms of where to draw the line between what's considered a valid sickness for you and what's not, just on interpreting that language of the Constitution and what is a sickness. And COVID-19 falls into that category because it's this sort of pandemic, ubiquitous kind of thing. But what's the line demarcating this from being, over inclusive? Where would that line be in your view? Because it seems like if you could point to a sickness, whether we talk about the COVID-19 box or not, but just interpreting the language of the Constitution, if a sickness is enough, it seems like any sickness is enough. And if I'm wrong about that, where would the line be?
I think the line is not in defining what is a sickness, because anxiety can be a sickness, the common cold can be a sickness. The line is whether you are unable to appear because of it. So I don't think that any voter would reasonably be able to say in good faith that I am unable to appear at the polls because of the common cold or the sniffles. I hate to cut you off, but we've heard, at least in this morning's argument, some pretty interesting examples of wanting to go swimming in November. If you want to go swimming in November and you stay at your buddy's house with an open pool in November during all of the hours, that's enough to make you unable to appear. So if you have a cold, why couldn't you just say, I'm choosing not to get out of bed today? Well, there's a difference in the sickness and absent out of town is obviously they're two different examples. But I agree with you that the absence from the town can be a very flexible authorization for absentee voting and let a lot of people who are clearly capable of going to the polls vote by absentee ballot. And I don't know, it would make no sense to interpret this provision of sickness more narrowly than that, in a way that would require somebody to actually be unable to, physically incapable of going. That would make no sense. And so I think I would agree with what Your Honor is saying, that this because of sickness language should be interpreted just as broadly as the other ones. I don't see why it wouldn't be.
Justice Ecker.
I'm wondering about two things, and they're sort of related, but I'll keep them separate. First, I'll just ask quickly. There's no claim here, as I understand it, of an abuse of power or a partisan effort, pretextual effort by the executive branch to issue this executive order for purposes other than the public health emergency that was declared. Is that true, just as a matter of what the record and pleadings show in this case?
Absolutely, Your Honor. The purpose of this executive order was to protect health and safety and ensure the right to vote.
But I'm just asking whether the plaintiffs have claimed
No.
that's a pretext. No. So the first question I'll try to keep it short, is just what checks and balances exist from your point of view in connection with 28(9) to prevent an abuse of power in connection, in the issuance of an executive order. Because you could imagine a situation in which something like this, is done for partisan purposes or improper purposes, I suppose, hypothetically. Are there checks and balances, or do we have a problem in that respect?
Well, the first point I would make is that issue is not before the court anymore. It's been.
I know. I just asked you the questions, though.
Yeah.
So if you can get to it.
Yeah. The answer is that there are checks and balances, Your Honor, and the statute says that it has to be done in the interest of the public safety. So there has to be that rationale to modify for the governor to modify a statute to act on.
Can the legislature come back and reject an executive order?
Of course, they could come back and they could revoke this or repeal the statute. They could. There's nothing that would stop the General Assembly from coming into session to review what the governor has done. In fact, that's exactly what they did. And they didn't revoke it; they ratified it because he acted properly in their view. But
the other question, and I'm just hurrying, I'm rushing you. I apologize, but only because of the time. The other question is a shift of gears, but it's really about police powers. As I understand it, anyway, for example, there's constitutional right to privacy, to property, to freedom of assembly, to travel, all kinds of things that can be impacted by an executive order during an emergency. The governor under the statute can say you can't travel, or I need your car and I'm taking it. Or you can't assemble in the way that normally we would think that the First Amendment would allow. And so my question is, I'm curious about why the state hasn't argued, or maybe it has, that we're interpreting this constitutional provision under extraordinary circumstances in the exercise of emergency powers in a time of a pandemic. Should that affect our interpretation of the Constitution?
Absolutely, Your Honor, and we have argued that and briefed it. It's at page 15 to 19 of our brief. We haven't had a chance to discuss it today because we've been focusing on the text. But
right, can you just briefly summarize your point there with and tell us what cases that we should read? I know it's in your brief, but I'd just like to hear it in a sentence or two. Yes,
the police power. This court has recognized, and that we've cited a number of cases in our brief, and there's lots more. The government's police power to protect the people from public health and safety emergencies like this is exceptionally broad, and it runs especially deep in this type of a context where there's infectious disease that could affect the whole population. And it's not just this court's precedents, it's the Jacobson case from the United States Supreme Court that I think is arguably the most important, because there the United States Supreme Court made it clear a long time ago, and it's been applied repeatedly by courts in this current pandemic, that the government has the power, its police powers are at their apex in this type of a situation. And that in this type of a context, even the most fundamental of constitutional rights have to give way to some extent to protect the public health and safety. And it would be an exceptionally bizarre result for the Supreme Court to say on the one hand that the government can restrain constitutional rights in the name of public safety, but for this court to interpret our own Constitution to say that the government cannot protect those same rights for that same purpose, especially when the constitutional provision that we're talking about, Article 6, Section 7, exists for the very purpose of protecting the right to vote. It just makes no sense. Yes, Chief Justice.
The issue that I have with that statement is who is the government at any particular time? Is it the executive branch or is it the legislative branch? The legislative branch can actually, and the people can directly through their constitution limit those powers, can't they?
Certainly, the electorate can limit the government's powers through the Constitution, but there's no constitutional limit here that would prohibit what the governor did, and the legislature delegated its police powers to the governor through 28-9B1, and has since ratified his opinion. So really, the question of who had the authority is not at issue in this case, but those powers exist, and they in this court, they should weigh very heavily on this court's interpretation of the text that we're dealing with, the purpose of which is to promote and protect the right to vote.
I think that's where, as the old expression is, that's where the rubber meets the road. That is the issue that is before us today, isn't it?
Not which branch, whether it's the governor or the legislature, because the legislature has come in and authorized.
No, that there was a constitutional amendment. There's a constitutional provision, and that provision is what we're trying to figure out right now. What does sickness mean? Does it mean the individual, or does it mean people generally? I believe the Texas court said there is no pandemic exception in Texas. I guess the question here is there a pandemic exception in Connecticut?
Well, I agree with you that that's the question in the case. My point with regard to the police powers of the state is that should inform how the court interprets the constitutional text, not that it controls over the text, but it has to inform how the court interprets that text.
Thank you, Mr. Scull.
And unless the court has any other further questions, I would ask the court to affirm the judgment.
Thank you very much. Attorney Doss, are you ready to proceed? You're muted, sir. You're still muted.
Thank you, Your Honor. Can you hear me now?
Yes, sir.
My Justice Sotomayor moment. Apologize. Thank you, Your Honor. I think what I'd come back and say is what this case is really about is whether everyone has the right to vote by absentee ballot, and under the state constitution, they can't. Our position is that healthy individuals should not be able to. The mere existence of COVID, the mere existence of Ebola, the flu, the cold doesn't give rise to that.
In order of hands raised, it's Justice Ecker, then Justice Kahn.
Just a quick question, Mr. Doss, following up on what I asked your opponent. There's no claim here. You're not making a claim that there's any pretext or partisanship or improper motive behind the declaration of the governor. That's not part of this case, right? Or wrong?
Well, it's inherent, Your Honor. It's inherent in the in re opinion of justices from 1862 decision. Because
no, I'm just asking about the facts of this case. I'm not talking about general political purposes.
Exactly.
I'm asking whether you're claiming in this case that Governor Lamont issued 7QQ and the relevant provisions here for improper political purposes.
When I say improper political, I'd say improper constitutional.
No, no, Mr. Doss, yes. I mean partisan.
Partisan, potentially.
To help his party rather than your party.
We don't have evidence of that, and that's not in the record, so I'm not going to be able to make an affirmative representation that this helps.
Is it in the complaint? Is it in the complaint?
It's not in the complaint, but it's in our brief this way, Your Honor. In re opinion of justices said the reason there's a restriction on why government officials shouldn't be able to change who can vote in an election by absentee ballot, and only the electorate could do that, is because they didn't want the elected officials being able to change the rules of election in the middle of the election. And that's what we do have here. These rules for an election are being changed in the middle of the election. So that, Justice Ecker, without coming out and saying that's partisan, because I can't represent that that's the case, that was the safeguard for what we have in the Constitution, and that's the violation that we're looking at.
Okay, thanks.
Justice Kahn.
My question to you, Attorney Doss, is I get your point. You're saying that by adding that exception, the COVID sickness, that basically it's allowing everyone to fill out an absentee ballot. But I have trouble with that argument, because anyone really, for any reason, like Justice Ecker's example, they can go to a friend's pool party, they can go to Rhode Island for the week, or the day and decide they'd rather not vote in person and rather vote by absentee ballot. My question to you is, you seem to agree that anyone, an elderly person who is afraid of being affected by COVID could check off sickness, just the sickness exception, because their immune system is suppressed. It's based on your own individual assessment. So my question to you is, instead of the absentee ballots being sent out in the form they were, if there was a cover memo that said, in light of Governor Lamont's order, if you are concerned about catching COVID because of your age, because of anything related to your condition or any condition you may have, you can get an absentee ballot. Some sort of explanation that sickness could include COVID basis. Would you be here today? Would that be okay with you?
Your Honor,
your client?
Yeah, so we're here today before the Connecticut Supreme Court because Judge McCousher issued a declaration answering this question.
No, but I know what Judge McCousher answered, but what I want is an answer to my question, my hypothetical. If instead of the form as it was sent, there was some memo, instead of the absentee ballot as it was sent with a memo from the Secretary of State explaining that in light of Governor Lamont's order, folks can check off sickness if they're concerned because of their age or some other medical reason that they don't have to disclose, that they can get an absentee ballot. Would you have filed, your client have filed the action? That's my question.
Yeah, and the answer is I can't speculate on that. What I can tell you is the reason we're before the Connecticut Supreme Court is because we now have a declaration that sickness applies to a general existence of COVID and not to the individual. And that's why before the Connecticut Supreme Court, I understand that that's, Attorney Doss, I understand that that's why you're before us now. But you did bring this action, correct, on behalf of your client? Correct.
And so that's why you're partly before this court, is that you brought this action. In fact, the first action you brought wasn't before Judge McCousher. You brought a different action, correct? That was dismissed for jurisdictional purposes. So let's leave aside Judge McCousher's decision. I understand that your argument is you believe he was erroneous, but I still want to get back to my hypothetical. And I understand you don't want to, maybe it puts you in a tough position to answer that question, but I wonder if what we're arguing about here is how a form was created.
So, Your Honor,
if you concede that someone who's afraid of catching COVID because of their age could legitimately check off sickness.
Your Honor, the reason the hypothetical is not one I can address because it would raise ethical implications about legal strategy of when an action would be brought and when they couldn't. And I'm not ethically allowed to speculate about that on behalf of my clients. What I'm presenting you with what the basis for this claim is, as well as why we're before the Connecticut Supreme Court, which is because a declaration was made that now has broad-reaching effect, both in the results of the primary and the general election, that Article 6, Section 7 applies to the existence of COVID and isn't tied to the individual. And that's squarely what's before the court. As far as speculating what else might have happened if facts changed, I'm simply not allowed to do that. And Your Honors, I'd come back to, and Justice Ecker, you talked about the authority here and Jacobson versus Massachusetts. I'm running out of time, so I want to be very clear about something. Jacobson versus Massachusetts is a case from 1901 that says that when the state had the power to restrict based on a quarantine, it had nothing to do with voting rights. And I want to be very clear about one of the worst decisions we ever heard when you study in law school was Buck versus Bell, which allowed for the mandatory sterilization of individuals with mental disabilities. The quote from the court was 3 generations of imbeciles were enough. The citation, the only citation in that case is Jacobson versus Massachusetts. That's the legal authority. That's simply not authority that should be applied today. You wouldn't be in good company if you supported, if you applied it. And finally, in conclusion, I realize I'm running out of time. I want to be very clear what this case is about, which is about voter enfranchisement. We have cited in our brief the objections that the Town Clerks Association had to the inclusion or expansion of absentee voting. What they said to us is 5 to 8% of those ballots are not counted. If I go into a voting booth and I drop my ballot into the machine, Your Honor, may I just take a moment to conclude?
Mr. Das, before you conclude, what did the fact finder say about that evidence?
This was legislative history, and it wasn't that we presented, and so there was no factual hearing that would revive the court to address it. It's simply acknowledging that there are simple policy considerations that should go into this evaluation of whether to expand absentee voting, and that's what our Constitution entrusts. That's what the Secretary of State said in 2012.
Is that before us, or is it before us the question of whether this issue of the judge's decision concerning sickness is correct in the Constitution?
So, Your Honor, it's before you in the context, as Your Honor alluded to, the Geisler analysis. What is the process when we're talking about contemporary concerns? That's why we look at the legislative history to determine what the law of absentee balloting has been in the state of Connecticut dating back to 1933, and we had significant statements in the legislative record explaining why we have that balance. This isn't a hyper-technical issue, and to just
we also have a legislature almost unanimously agreeing, passing a bill that says, despite all of that history, this is how the people feel right now at this moment.
Well, to be very clear, they didn't interpret the Constitution, so that constitutional provision is still what applies, and that's what you're being asked to decide here.
Doesn't that cut against the argument you just made?
I don't think so, because I think it evaluates, again, what the policy concerns are on each side. And for that reason, we have that restriction in the state constitution. And to Justice Ecker's point, where's the check? Where's the accountability? It's in the state constitution. The electorate took this away from the leadership. They don't get to change it. Everything has to go through electorate. And that's why the secretary went to the General Assembly and said, please ask the electorate to amend the Constitution. And only for the second time in 50 years, the electorate said, no, we are not expanding absentee voting.
Thank you.
Thank you. With that, we'd ask that the decision below be reversed. Thank you, Your Honors.
Thank you very much, Mr. Das. In order to avoid a problem that we had in Fay 1, when I adjourned to make my decision, when I got out of this room, some people lost connection to the hearing. I think it was the YouTube feature. But I'm going to ask the clerk of the court if he will remain online, because what we're going to do is we're going to see if we can decide this quickly with a written opinion to follow, or we're going to need more time. So we're going to adjourn to a different room, but I don't want to lose connection with this room. And I'm not sure if I'm doing a bit of overkill here to ask the clerk to stay online, but we will notify the parties and the public if we come up with anything as quickly as we can. Okay, so we'll be in adjournment to conference, and then we will be back as soon as we possibly can. Mr. Dage, if you will stay on, and maybe the IT people can help address that issue about whether you have to stay on or whether we can rejoin this room. Okay.
Certainly, Mr. Chief Justice, I can make myself available.
Thank you very much.
Thank you.
We are adjourned.